Hey, everybody. This is Charles Cook here, managing partner of Cook Baxter, going live this morning with the new regulations from the Immigration Service. We wanted to get this right out there so people know exactly what's going on and making sure that our clients are fully aware of the options that are now available to them to obtain parole in the United States for those that are married to the United States citizens before June 18th, 2024. Marriages after that date won't count. They must have been citizens by that date, so citizenship after that date doesn't count. Stepchildren can also qualify for this program as well, as long as that relationship existed before June 17, 2024. And finally, the person applying, that is the foreign national, must have been in the United States for 10 years prior to June 17, 2024. They can have had minor departures, which gets us to a couple of the big questions in the United States. So these 10 years, if you left briefly for a short period of time that was not an order of deportation or voluntary departure, and you didn't get anything legal outside the United States, you can apply for parole. So what this means is individuals who have a 3 or 10-year bar and individuals who have a 10-year bar are eligible for parole under the new Keeping Families Together policy. So this is really big deal because if under the new Biden Keeping Families Together program, if you have a 3 or 10-year bar, you can apply for parole. Now, here's the catch. There's no extensions to this parole. That's it. It's a one-time parole. And after 3 years, it's gone. You will get a work permission. So if you have a permanent bar, you can apply for this. For 3 years, you'll have a work permit and you'll be paroled. Now, I don't know what's going to happen if Trump's president. 1, 2, if nothing changes, after 3 years, you have nothing. Except what the government has after 3 years is your information. So is there risk involved with this? Of course there's risk involved with this. So make sure before you decide, before you jump in both feet to apply for this parole with a permanent bar, that you understand the risks. A Trump election, which is maybe why you don't want to apply until after November 5th. If Trump loses, then apply. 3 years, no renewal. You're not getting a green card. All of the bars to adjustment are bars to adjustment. So you still have a lifetime, basically the lifetime bar, needing a 10-year presence outside the United States to get that waiver. But you get a work permit for 3 years. For those people who have 3 and 10-year bars, we know, basically if you have that, it's because you came back with a visa and you're serving that time in the United States. I'm not really that worried about the 3 and 10-year bars because you have in effect. Now, if you have no bar because you've never left, this parole program is golden. You need to do it. You need to jump in with both feet and go forward. So that's the first thing that jumps out from the regulations that immigration puts forward. Again, they're confirming they're charging $580. You're going to need proof of identity, proof of your marriage, proof of your spouse's citizenship, lots of proof of your physical presence in the United States for the last 10 years. They did not set specifically how much evidence, and they're going to judge everything based on the totality of the circumstances. And they said this: if you have a final unexecuted removal order, you may provide additional documents that you believe demonstrate your parole is warranted. So even with a removal order, you can apply for the parole, because keep in mind, you can apply for a waiver inside the United States with a removal order. That's not an in absentia removal order. Again, this is why you have to have legal advice here as part of this process. Now, the next step here for people, the form is out. So people that are in removal proceedings, you are eligible for this program. They will consider your request if you're currently before an immigration judge, including if your case is at the BIA or your case is administratively closed, or if you're released on bond just waiting for something. They're going to consider, again, why are you in deportation? It all goes to considering parole. There's going to be a lot of people denied. Understand that. A lot of people are going to apply. They're going to be crappy lawyers. They're not going to get honest advice. And please don't use a notario. And they're going to get denied. All right. Now they do say a person who poses a threat to border security will be disqualified. That's the guidelines for civil immigration enforcement. So your priority. Now, if you have the removal order, you still might request the parole in place as part of this program. If you were removed from the United States under an order and re-entered, you will, whoa, this is good. All right, so forget what I said earlier. If you were removed or departed under an order of exclusion and re-entered, you will not be granted parole. If you left on your own and came back, you can be granted parole. So two different circumstances to be clear. If you left because you had an order or VD and you came back, you're barred. Okay. If you left because you just left because mom was sick or whatever, you can still apply for this. You have to rebut a presumption of ineligibility with a final unexecuted order. There's all kinds of things that go into this. It's a very complicated process. The next thing I want to get into is criminal charges. Again, any felony of any kind, done. They're just done. There's nothing there that you qualify for. And that goes any controlled substance offense except for 30 grams or less of marijuana. So basically one marijuana conviction. Everything else if you any criminal offense, excluding minor traffic offenses, is a presumption of ineligibility that you have to overcome. Again, more work, more pleading, more lawyering that goes into this. More the reason why you've got to use experienced lawyers in immigration law to get these cases done. And if you've got even misdemeanors, let's say a DUI, you have a presumption that you're excluded, that you're not eligible. Any misdemeanor, and I presumably that would include something like trespassing, would disqualify you with the presumption that you could possibly overcome. Anybody with a pending criminal charge, out, not eligible. Anybody national security, border security, public safety, out. You're out of the program. And this is a crazy one. Anybody with a dismissed, expunged, vacated, pardoned, deferred, annulled, invalidated, withheld, or sealed conviction is subject to presumption of ineligibility. What? Oh my gosh, I guess the Constitution doesn't apply here. They talk about going overboard. This is clearly going overboard. So you can overcome that presumption by showing positive factors, which include things: how old were you when it happened? What was the sentence? What was your rehabilitation? Basically, this is like doing a 212 waiver. This is going to be a crazy amount of work to get these. It's like a 42A. This is going to be an enormous amount of work to get this stuff done. Enormous amount of work. But driving offenses, running a license, don't need to worry about. Be just fine. Juvenile delinquencies do count and create a presumption of ineligibility. Wow. Just absolutely crazy. Now, after you make the decision, you can't appeal it. But you got to send your new $580 fee in with that. And let's see what else we got here. If they deny it, no money back. If you got a 601A pending, you can do this, but they're not giving the 601A money back. Okay. If you're denied the request, you will generally not be issued a notice to appear unless they think you should be given a notice to appear because you're a threat to national security, public safety, or border security. Let's see, the employment authorization. If they approve it together, you can then apply for the EAD. So the 580 is for the parole. It cannot be filed with the EAD. You file that after your request is approved, which of course is also $470 as part of the fee. If you file on paper, send them by mail, is $520. So what else we got here? It's a new form of 131F that you're going to file, and you'll get the work authorization. That will be good for 3 years, the period of validity of the parole. But obviously, most people are married to citizens and can adjust status for this. That's the primary purpose of this. I don't think there's 500,000 people, as they said, but it's possible. Let's see. Anything else here? That's about it. For the adjustment of status, you have to be otherwise adjustable. The 3 or 10-year bars, the parole does not overcome the 3 and 10-year bars. Certainly doesn't come up the permanent bars. So that's our quick and dirty look at this regulation. We'll be back probably this evening or later today at noon. I think my partner Dustin's going to come live at noon today to talk in more details about this, or maybe at 1 o'clock, talking more details about this. Until then, of course, you can reach us if you want to make an appointment. You call 404-816-8611. Happy to meet with you about this program. You can email us for details about the program. We got a couple questions here. Do we think the documents submitted for physical presence should be PDF for each year? Well, we're doing it ourselves. So we're gonna load up one document, one PDF to their maximum size. So we have to put multiple ones in. We're gonna put multiple ones in. Edgardo, ¿cree que es necesaria vencida mes? I think you have to prove month by month. That's my opinion. Mes por mes, get everything every month as if you can. Okay. Deportation be closed for, or can I? No, you can apply while deportations are open, Jay. So you can apply now. Case administrative, your administrative closed. You can apply now, get the parole, go back and reopen the case. 1, I have a final order removal. I sent my motion over last month. You can apply now. You can apply now for the parole. You don't need to wait. And adjusting status for this program needs to leave the country. No, the adjusting means you do it in the country. But this program is to give you parole, not to give you adjustment. It's different things. How long do you take? We have heard rumors that they'll do the early cases in a few weeks. I would not hold my breath. These are going to be very complicated cases if you have any criminal activity at all. And I would suspect anywhere from a month to, first ones will be done quickly, but average processing time, probably several months. My husband has voluntary return. Does that apply to yes or no? Question removal. If he's got voluntary departure and has not left, yes, he can apply, but he has a presumption of ineligibility. And Quantum Lee, thank you very much. Again, my partner will be back later today. If you have any questions or comments, you just go ahead and call me. Si quiere llamarnos por una cita, llama ahorita y por supuesto puede mandar un email. Estamos en contacto. Hasta luego. Bye bye. See you later. Be back later today.